Good morning and good afternoon, everyone, depending on where you're located in the country. Thanks so much for joining us for today's LEHR webinar entitled Getting Giggy with It, a review of recent developments in the law regarding gig workers and how it impacts Canadian employers. My name is Matt Link, and I'm a partner in Fasken's Labor, Employment, and Human Rights Group based out of Toronto. I'm so pleased to be joined by a couple of my colleagues who I'll introduce to you in a moment. But before I do that, I'd like to draw your attention to this informational slide, which provides some important information about not only the session materials that you'll be able to access after the webinar, the ability to ask questions is set out there. Importantly, I'll add as well that today we have two polls. To join the poll, make sure you're in the audience chat, and under the chat box, click on the polls tab. We'd also like to draw your attention to the survey piece. As always with this seminar series, we very much value your feedback and your input regarding these sessions, and we would certainly be grateful if you filled them in before you log out of the session today. For those of you that are attending and receiving CPD certification credit for this seminar, we're continuing our automatic CPD certification process. At the end of the presentation, a QR code is going to appear on the screen, and you can use that link that's added to the audience chat in order to get your Ontario or your Quebec CPD credits. So as indicated, I'm so pleased to be joined by two of my colleagues in the Labor and Employment and Human Rights Law Group in our Toronto office today. First is Awale Deria, who's an associate, as I said, in our office. He maintains a broad labor, employment, and human rights practice. Awale is an experienced litigator and provides practical legal advice and representation to employers. With him, my colleague Jake Wagner, who's also an associate in our Toronto office. He has a broad practice in all areas of labor, employment, human rights law, and represents both unionized and non-unionized employers. And with that, let's start this session. In preparing today's session, I just thought I'd note that the gig economy and developments in employment law and regulations with respect to the gig economy and gig workers is a new topic for us. It's a brand new session. And so we're so pleased to be sort of spending the next 90 minutes with you to hopefully provide you with an introduction into the area for those of you not familiar with it. And those of you who are familiars or who may be gig economy employers, provide more of a deep dive into both some interesting legislative and case law developments. Quick overview. We'll start by defining the gig economy. What is it? You've heard that term a lot. Well, what exactly does it mean? And why is it such a big deal? What are some statistics around the gig economy in Canada? What are some advantages and disadvantages for employers who contract with workers as part of the gig economy? We'll then talk about the legal landscape, including some very recent and substantial developments on the legislative front in some areas of this country related to the regulation of gig work. We'll talk about a couple of key decisions, both in the area of class actions and general litigation, and then finally wrap things up with talking a little bit about where unions fit in all of this, because they do play a role, and There have been some very interesting developments in this area as well. And so to kick things off, I'll turn it over to Awale, who'll start with just telling you all about what the gig economy is.
Good morning and good afternoon, everyone. Thanks for joining us. We appreciate you taking the time out of your day to get giggy with us. So, as we mentioned, let's get into the main point of why a lot of us are here today and start by asking ourselves, what is the gig economy? The gig economy is essentially a modern labor market driven by short-term, flexible work arrangements where individuals are hired for specific tasks, or as it's called, gigs, rather than permanent positions. The gig economy is also largely comprised of on-demand, freelance, and temporary work arrangements that offer flexibility, however, often lack traditional benefits and protections found in more stable, permanent employment relationships. Gig workers typically include freelancers, independent contractors, and platform-based workers. In this system, gig workers often enter more casual work arrangements, such as I mentioned, short-term contracts with firms or even individuals to complete specific and often one-off tasks. Some defining characteristics of the gig economy include independence and flexibility, and by that, gig workers often enjoy greater control over their schedules, choosing when and how much they work. Now, this typically appeals to those seeking a more work-life balance or even additional income alongside their permanent full-time or part-time positions. Another defining characteristic is the low barrier to entry. Many gig economy jobs don't require specialized skills, making them accessible to a wide range of people looking for immediate work. And as you can imagine, this inclusivity contributes to the growing number of gig workers that we're seeing. Another defining factor is that the gig economy essentially has a global reach, and it's not limited by geography. Many freelance gigs, especially those in the fields of design, writing, and programming, can be done remotely from anywhere in the world. And finally, a staple of the gig economy is that it is, in fact, technology driven. And so platforms and apps serve as intermediaries between gig workers and consumers, making it easy to find jobs, receive payments, and manage work on a day-to-day basis. Now let's look at some common examples of gig work. This shift in work structure, again, has grown significantly with the rise of digital platforms and apps that connect workers with customers or businesses. Common examples include ride-sharing drivers like Uber or Lyft, food delivery workers, such as those for DoorDash or Uber Eats, freelancers in creative fields like writers, designers, or programmers on platforms like Upwork, Fiverr, and even part-time consultants. Instead of working for one employer on a long-term basis, gig workers typically take on multiple temporary assignments, or again, as it's called, gigs, through platforms like Uber, Upwork, or DoorDash. Now, these jobs can vary, as you can imagine, from driving, delivery, home services, to more specialized work like we discussed. However, other common examples of gig work that might not immediately come to mind include individuals who rent out their properties as short-term rentals with Airbnb, or artists or entertainers. As you can imagine, like most subjects, and before moving forward, sort of the reason for that is, again, it offers added flexibility and an additional source of income for individuals. And so, as you can imagine, like most subjects, gig work has been the center of much debate. Proponents argue that it offers flexibility and entrepreneurial opportunities, while critics point to issues like income instability, a lack of benefits, and the potential for worker exploitation. Now, the reality is the gig economy is reshaping the future of work. And as we'll discuss further and later on in this presentation, ongoing discussions are focusing on how to protect gig workers without stifling the innovation and flexibility that the model offers. So now that we know what is the gig economy, let's look into who is in the gig economy. So for this portion of the seminar, we facilitated a poll for the audience to tell us, what do you think is the most common type of gig work in Canada? Now, just so you know, I haven't spoiled the answers with my colleagues, so their guess is likely as good as yours. But while we're waiting for you to enter your choices, Matt, Jake, what are your thoughts?
Oh boy. Good question. I mean, I'm just going to say transportation services, because that's probably the one that I use the most. But boy, A would probably be close to. I don't know. What do you think, Jake?
I don't know. I've been on the streets of Toronto lately, and in Vancouver, and you see a lot of people on the corners handing out free samples and trying to move things that way. And so, I think promotional marketing's been around for a long time. And when Awale talked about graphic design and other elements, I might be promotional marketing.
So, number one at 38%, people thought food delivery and catering. Wow, IT services, 29%. Transportation services, 25%. And then last at 6% was promotional marketing.
Well, I really think the 6% has it. I'm not a betting man, but
well, Awale, we're waiting with bated breath. What is the answer?
Well, let's all be happy Jake didn't gamble his life savings on this one. What I did was I thought, a lot of times with these polls, there's only one winner, and I thought maybe make it so there are two. So the actual answer is the most common type of gig work is rideshare services and food delivery. So that would be A and D. So for those who selected either of them, you're a winner in my books. Let's move on to some gig economy statistics. And I promise I will make this as smooth as possible. It's statistics. If you're anything like me, I thought I left that behind in the 10th grade, but it seems to haunt me on an ongoing basis. So I'll smooth through this portion as much as I can. Earlier this year, in March 4th, in March of 2024, Statistic Canada released a reference report titled Defining and Measuring the Gig Economy Using Survey Data. And this report provides a statistical framework and a measurement strategy for three overlapping components at the core of the gig economy. The first is gig work. The second is digital platform employment. And lastly, dependent self-employment. Now, these three components, which I will define shortly, again, gig work, digital platform employment, and dependent self-employment, are essential concepts to understand the evolving nature of the gig economy. While there's notably overlap between these three forms of work, each can also occur on their own. And so gig work, to begin with, we've discussed, is a form of work characterized by short-term jobs or tasks, which does not guarantee steady work and where their worker must take specific actions to stay employed. Digital platform employment refers to paid work carried out on or through internet platforms or apps, as we've discussed, Uber, DoorDash, which exercise control over the work process. And finally, we have dependent self-employment, which refers to self-employed workers who are operationally or economically dependent on another person or business, such as a main client, a supplier, or even in some cases, an app. Some of the highlights in the report demonstrate an obvious growth of the gig economy in Canada. If we go back to 2022, there was an average of a little over 500,000 people who were self-employed and relied on a single business relationship where the other party exercised a large extent of control over key dimensions of work, such as their schedule, the organization of work, their prices, or the supply of tools or material. In 2020, at the end of 2022, that number jumped from a little over 800,000 Canadians who are aged between 15 and the age of 69 that had a main job feature characteristic that was consistent with the concept of gig work. And this included, amongst, like I mentioned, almost 900,000 Canadians, 624,000 Canadians who were self-employed. And of them, about 250,000 who were employees. So that means these 250,000 employees had regular permanent employment, and this was an additional source of income. And an additional 1.5 million people had completed gig work at some point during the previous 12 months. So just to show you sort of this is a growing field. And again, more recently, as you can see on the screen, in 2023, Statistics Canada stated that up to 3.3% of the population aged 15 to 69 reported that they had engaged in digital platform employment, which is, it's a sign of the times. And so moving on, we live in a gig economy. That's just a reality. And today, approximately 9 million Canadians say that they are part of the gig economy, which is equivalent to 28% of the country's population, according to a recent H&R Block report. That number is up from 22% who made the same claim in 2022, according to the same report. And 12% more Canadians are currently considering the option. Now, the ESDC previously noted that the share of gig workers among all Canadian workers jumped to 10% in 2020 from just 5.5% in 2005. So that is a significant jump within that 15-year period. Now, overall, 58% of gig workers say that they started working in the gig economy to generate extra income due to the financial pressures and the increased cost of living. And that's not surprising because further statistics show that nearly 3/4 of Canadians today, that's 73%, say that the rise in cost of living makes it hard to afford everyday expenses. And up to 24% of Canadians are struggling to pay their bills. And so with that, my final statistic for you is overall, and again, 72% of gig workers indicated it's a second income to their primary employment, compared to 28% that report that it serves as their sole income. And this is just domestic. Let's look at what's happening around the world, because the gig economy is not limited to our borders. It is a global phenomenon at this point. And so while developed countries currently dominate the demand for gig workers, a report by the World Bank has shown that the demand in developing countries is growing at a much faster rate. For example, in sub-Saharan Africa, job postings on the largest digital platform grew by 130%, while the growth rate in North America was just 14%. And so almost 60% of firms surveyed in these developing countries reported increased outsourcing to gig workers. In the more developed countries, less than half said the same. And so as a result, taking all these stats together, reports have found that the gig economy is vast, with a total of over 545 online gig platforms, right, across the globe, with workers and clients located in nearly 190 countries. Interestingly, close to 3/4 of the platforms are regional or local rather than global. And underlying the significance of this sector for developing countries, the report found that together, low and middle income countries account for 40% of traffic to gig platforms. And so now that we've discussed what is gig work, who is a part of gig work, where is gig work performed, let's look and let's discuss why gig work. As we continue to explore the gig economy, it's important to consider how this labor model impacts employers. On the one hand, the gig economy offers businesses greater flexibility, allowing them to scale their workforce based on demand and access to a broader pool of talent without the long-term costs associated with full-time employees. However, there are also challenges, such as managing a less stable workforce, potential quality control issues, and legal risks surrounding worker classification, which my colleagues will discuss later on in this presentation. In the next section, we'll dive into the key advantages and disadvantages for employers who engage with gig workers. So as you see before you, one of the key advantages of engaging with gig workers is the increased flexibility. Gig workers allow companies to avoid the high costs of a permanent workforce by hiring only as much help as is needed and required. This flexibility provides significant, or has the potential of providing significant cost savings by eliminating the need for long-term employment commitments and associated expenses. In addition, the flexibility the gig economy offers helps companies respond rapidly to shifts in the marketplace. Hiring gig economy workers allows companies to scale up or down quickly depending on their needs at any given time. This is especially useful during times when there's an increased demand for certain services in a specific sector, but no need for a permanent employee base. And so companies can easily vary the number and composition of their workforce in response to changes in demand, allowing for more efficient use of available resources. Another key advantage of employers engaging with gig workers is, of course, diversity. Companies that take advantage of the gig economy gain access to a large pool of talent and a wide range of skills that may not be available in the traditional workforce. Businesses can easily and in a much quicker manner find qualified freelancers to fill positions. Businesses in the gig economy have the flexibility to hire people of varying ages and skills to complete a wide range of tasks. And the diverse background of gig economy workers can indeed lead to greater business innovations and ideas. Finally, a key advantage of the gig economy is, as we've mentioned up until this point, cost effectiveness. And one of the incentives to dive into the gig economy is the potential for financial savings. Freelancers are typically, more often than not, less expensive than other workers and independent contractors, since employers do not have to cover benefits or onboarding costs linked with full-time employment. By hiring freelancers or contractors for specific projects instead of full-time employees, companies can reduce their labor costs while still getting the job done quickly and efficiently. In addition, compared to other regions of a certain country or across the world, employing local talent may at times be more expensive. And as a result, with this, the global opportunities that come with gig work, businesses may explore gig workers from abroad in this sort of situation. Now, like all things in life, it's not all sunshine and rainbows. While there are advantages, there are, of course, disadvantages, or should I say potential risks with engaging gig workers. The first of which, as you can imagine, is the lack of commitment and loyalty that employers might be faced with in such a circumstance. One of the key challenges for employers in the gig economy is the lack of commitment and loyalty from gig workers. Unlike traditional employees, Gig workers are typically focused on short-term assignments and may juggle multiple gigs across different platforms. This means they don't often feel the same sense of long-term investment or loyalty to a single company. For employers, this can result in higher turnover rates, inconsistent performance, and the need for constant recruitment and training of new workers. Additionally, since gig workers often have the flexibility to pick and choose assignments, they may prioritize opportunities that offer better pay or conditions, leaving employers struggling to fill gaps during busy periods. Without the stability of a committed workforce, companies may face challenges in maintaining a cohesive team culture and ensuring the consistent quality of service that comes from dedicated employees. Now, finally, in addition to that, balancing this with the cost savings and flexibility of gig workers is a complex issue that many employers must navigate in this evolving labor market. Finally, well, not finally, we actually have more bad news to come. Sorry. Another disadvantage is possible ethical issues. In some cases, businesses that operate in a gig economy are criticized for the ethical practices they perform. Many gig workers are treated as independent contractors, which means they aren't entitled to benefits like health insurance or paid time off or job security. And this raises the question about whether these workers are being fairly compensated for the risk they take on, given, as we mentioned earlier, they are typically paid much less than an independent contractor who typically comes on for a much larger period as opposed to a single one-off task. Another ethical concern is the income instability that comes with being a gig worker. Gig workers often face unpredictable workloads and fluctuating wages, making it difficult to plan financially. Additionally, the lack of legal protections leaves gig workers vulnerable to exploitation, with some companies exerting significant control over their labor without providing the corresponding support. The gig economy has come into question with fair treatment of freelance workers. Employers need to be aware of these ethical issues as they may arise over time. Finally, there are legal implications and legal considerations to bear in mind when recruiting a gig worker. Again, a key legal challenge is defining a gig worker status. Are they independent contractors? Are they employees? This classification is crucial as it determines the rights and protections workers are entitled to. From a tax compliance perspective, from a notice perspective, to the anti-discrimination and anti-harassment protections that may apply. Factors such as the level of company control and worker independence influence this classification, often leading to legal disputes. A prominent example is the Uber decision, which my colleagues will discuss later in this presentation, and its classification of drivers as independent contractors, which has sparked legal battle with drivers and labor advocates arguing that the company exerts significant control over their work. Now, employers must properly classify their gig workers and should take adequate steps to document the nature of their relationship with their gig workers. And they should ensure that they do not exert too much control over their gig workers, which can lead to the gig workers being reclassified as employees and resulting in them being entitled to all the rights and protections that come with that status. Now, while gig workers are not entitled to all the same statutory protections as employees, in some jurisdictions, which we'll discuss further later on in this presentation, certain statutory protections still apply. And so when hiring gig workers, employers must ensure that they have a clear and comprehensive understanding of their legal obligations. And this means employers must also be mindful of their handbooks, policies, procedures, and they should carefully review these documents to ensure that they have a clear understanding of their implications and they should make revisions as necessary to reflect their use of gig workers. Now, with that being said, what is the trend towards enhanced rights for gig workers moving forward? One of the prominent employment law themes in 2023 in Canada has been the increased interest and attention to the working conditions of individual gig workers. This, perhaps unsurprisingly, given that the share of Canadian workers who perform gig economy work has become increasingly high and continues to rise. However, as more Canadians engage in the gig economy, the regulation of this type of work becomes increasingly crucial, highlighting the growing importance of establishing effective regulatory measures. Public consultation to this end are well underway, and frameworks for the regulation of gig work are starting to appear in some Canadian jurisdictions. And with that, I will transition over to my colleague, Matt, who will tell you some more about the legislation surrounding gig work in Canada today.
Well, that was an ideal transition, Awale. Thank you very much. And thanks for really sort of a whirlwind, broad strokes, a background, an introduction, an overview of the concepts of gig work and things that you should consider. So sort of, putting that now into practice, and particularly if you're a Canadian employer, it is good to know that our federal and provincial governments have given this broad change in the economy some thought, and have in many cases gone further than that and actually introduced legislation, in one case in the province of British Columbia, which I'll talk about in a moment, significant legislative changes that were just implemented in the last 2 weeks. In terms of both for federally regulated employees and provincial governments for provincially regulated employees, governments giving some thought to some of the things that Awale touched on in terms of the challenges as it relates to regulation of gig work and where there may be gaps. The sort of flurry of discussion and legislation really started in late 2022 and early 2023. And as good a place as any to start with is the Federal Minister of Labor's report on called What We Heard, Developing Greater Labor Protections for Gig Workers. Essentially, the federal government engaged in an almost 2-year consultation process between February 2021 and the end of 2022, hearing from all different kinds of stakeholders in order to better understand gig workers' experiences in federally regulated sectors. And because it was a consultation report, an information gathering one, and for purposes of seeking as broad an input as possible, the federal describes gig workers as individuals who enter more casual work arrangements, such as short-term contracts, to complete specific or one-off tasks. So not necessarily linked to digital labor platforms, but they can be. Next slide, please. What the federal report summarized, and this is applicable both to provincially regulated workers and to federally regulated ones, is some of the key challenges faced by gig workers in Canada. And Awale touched on one of the key ones earlier, and that appears first in this slide, and that's misclassification. What exactly is a gig worker? Are they an independent contractor? Are they an employee? Or in some of the provinces, you have the intermediate concept of a dependent contractor. What about rates of pay? One of the key challenges with respect to gig work, particularly those delivery drivers and transportation drivers that so many of us utilize, there is a real issue in terms of how are they paid and whether they're paid for all of the time that they would consider working, but which an employer might say you're not working. You're waiting for a ride. You're waiting to pick up a delivery. Should you be paid for that? Or shouldn't you? And how does that impact your overall compensation? The risk of late or non-payment by providers, Awale indicated that, it's not just Uber and DoorDash. There are many, many smaller providers who perhaps may not have the same reputation or the resources as the big players. Unpredictable schedules, the risk of unsafe work conditions, also the question of when there's a workplace injury, is there workers' compensation that applies? And if so, who's responsible for obtaining it? And then finally, limited access to dispute resolution procedures. So, for example, if you're a federally regulated gig worker, and you've got an issue about a wage payment or a termination, does the Canada Industrial Relations Board even have jurisdiction to hear your complaint if the entity you're contracting with argues that you're an independent contractor? So, in terms of where things go with the federal government, they're still in the information gathering phase. This usually happens with the federal government and the regulation of employment or quasi-employment type relationships. But the Minister of Labour has signaled that they intend to implement some of the findings from the report and to amend the Canada Labour Code to take into account and to address some of the gaps concerning gig workers and gig work. And I'm not a mind reader or a soothsayer, but I can only say that looking at the way that the Federal Minister of Labour, ESDC, and the federal legislators have dealt with legislation of key areas such as, for example, workplace harassment and violence complaints, and most recently, paid sick days. It wouldn't surprise me that while the government is often a little bit behind in relation to its provincial counterparts, when they catch up, they tend to go big. And so I think, for those of you who are federally regulated employers, I think the message is stay tuned, but also, as we'll get to in a moment, keep an eye on some of the cutting edge developments from at least one of the provincial jurisdictions as to where things may be going as it relates to future amendments to the Canada Labour Code regarding gig workers. Next slide, please. Ontario really was sort of in this country was sort of first out of the gate with some form of regulation providing for rights for workers performing what could be called gig work. Certainly, it's the country's largest province, and it's been a political hot potato. And so, the government did hear this, and they did move to enact legislation, and most recently, a regulation that's going to come into force next July. Unfortunately for worker advocates and unions, at the end of the day, the overall result here is perhaps, in the view of some, that the government really didn't go far enough. That was largely geared towards a reaffirmation of certain rights that were already available under employment standards legislation. So, for example, the right to information about digital platform operators being prohibited from making deductions or withholdings from earnings without authorization. That's already provided for under the ESA. The right to minimum wage, that's already provided for. The right to keep, for workers to keep the tips and gratuities that they receive, and the right to have a form to resolve work-related disputes. And as I said, the response to this legislation was lukewarm at best. And if you listen to the Gig Workers United Union, which is affiliated with the Canadian Union of Postal Workers, they went so far as to, quotes, condemn the legislation. One of their many issues is that the legislation doesn't really address the gap that you have as it relates to minimum wage. So, for example, a worker is only paid during engaged time. And the fact that they are actually there and ready to work, ready to perform their duties, but not actually being paid until they're engaged, may have the effect of them actually receiving less than minimum wage. So, look, it's a start. Ontario was the first out of the gate. But again, certainly those who advocate for employees think that the government and perhaps other governments could do better in the future. Next slide, please. Another province that is looking at a regulation of gig work, not specifically looking at gig work only, but really undergoing a comprehensive review of its legislation. It's the first one that it's done in about 12 years, is the province of Saskatchewan. It's going to be looking at a whole host of areas, but one of those is in the area of gig work. And this is something that Canadian Association of Employers Council sort of made some submissions on. I think that we are going to see a report from the Ministry of Labor Relations and Workplace Safety in terms of some of the input that they received. And certainly the ministry has signaled that this is an area where they will have to legislate. And if you go over to the next slide, just a quick quote from the report, seeking input. Government says a growing trend of reliance on contract workers and growth in the gig economy, whereby workers are typically treated as self-employed, is something that they are going to target. So will legislation follow? The trends say very likely that they will. So let's move on to where I think we have sort of the real meaty area of legislation as it relates to a gig work from an employment or a quasi-employment type perspective, and that's in the province of British Columbia. The government introduced amendments to both the Employment Standard and the Workers' Compensation Act in late November of 2023. Next slide, please. In 2024, it announced specific regulations targeted at app-based ride-hailing and delivery workers. And those regulations came into effect just a couple of weeks ago on September the 3rd, 2024. And it's worth taking a couple of moments to look at what the online platform workers regulation provides for. I don't want to use the term, revolutionary, but I think it's certainly innovative. And it goes certainly beyond any other employment standards type legislation in this country. And I think that, as certainly we're counsel who represent employers, if you're an employer, an HR professional, a labor relations professional, or in-house counsel, I think we'd all be wise to look to British Columbia as perhaps signaling as where things are going to go in the future for the regulation of this work in other jurisdictions. First of all, the hourly minimum wage. Key development here. BC minimum wage right now is $17.40 an hour. Under this regulation for app-based gig workers, it applies a 20% premium. So minimum wage jumps up to just under $21 an hour. And not only that, it defines engaged time as time that begins when the worker accepts an assignment, not when they get to the assignment, but when they accept an assignment, all the way through to that assignment's completion. Engaged time doesn't include time waiting between assignments. However, the government has recognized that that takes time and effort for these workers, and that is what has justified the 20% premium in the minimum wage. Next area that is new, and certainly new and different compared to any other employment standards legislation in the country, relates to expenses. The legislation provides for an expense allowance to compensate workers for the costs they incur in terms of using their personal vehicles to work during engaged time. 45 cents per kilometer for ride-hailing assignments, 35 cents per kilometer for delivery assignments, and that includes when using e-bikes and scooters. Really something we have not seen before in employment standards legislation. And given the number of people engaged in gig work, as Awale reviewed earlier, it's going to potentially apply to a lot of people. Tip protection, again, ensuring that companies are prohibited from withholding or making deductions from tips. If you receive tips, the tips are 100% yours. Pay transparency, ensuring that if a platform company offers you as a gig worker an assignment, you can see what the estimated earnings are for completing it. And you're required, the company is required to provide you with a wage statement every pay period to ensure that you're paid properly. Something called destination transparency, required to provide all pickup and delivery locations within 300 meters when offering an assignment to a worker. It's pretty remarkable stuff under a regulation that's associated with employment standards legislation. And this allows essentially workers, I know that, one of the issues is, okay, are they employees or are they independent contractors? And too often they're misclassified as independent contractors. But here you have someone who's treated as an employee under the legislation that's kind of acting like an independent contractor, because with destination transparency, they can assess the desirability and safety of assignments before deciding to accept them or not. Prohibitions on suspensions and terminations of workers without notice or a written reason or justification. And then importantly as well, workers' compensation coverage. In BC, that's under WorkSafe BC. That'll apply to all ride-hailing and delivery workers, with the platform companies being responsible for registering for coverage with WorkSafe BC and paying all premiums for the workers that they contract with. So that's a lot. And I think you'll see, looking at that regulation, it's a stark difference between that and the Digital Workers Platform Act regulation in Ontario. And the reactions from both employers and employee advocates has also been interesting. This time, unions and such as Gig Workers United and Unifor have hailed the new legislation as being transformative and progressive and pointing to the future. Basically, they've applauded and showered praise on the BC government. Conversely, employers and platform companies have been quite critical of some of the areas that are covered by this legislation, particularly the higher minimum wage and also the 35 to 45 cent per kilometer vehicle allowance. Uber in particular has taken issue with this and says that it amounts to a rideshare expense that's like 50% more than in some US states. The argument is that the cost will simply be passed on to the consumer, which will make it more difficult for people to afford. And on the delivery side of things, it will just result in fewer companies being able to afford to use these services. Again, it's been less than a month since it's been in place. I think that, the reaction from the employee side and employer side is perhaps not surprising, but I think it's also reasonable to expect that if you're in a province that's not British Columbia, or you're a federally regulated employer, it's probably more likely that once these areas are legislated, they're going to look a lot more like the British Columbia legislation than the Ontario legislation. So stay tuned and be prepared. Next slide, please. Before I turn it over to Jake to talk about some of the sort of key legal decisions in this area, I'd just quickly point out, and really, Awale has indirectly touched on this, that gig work is not unique to Canada or North America. It's a worldwide phenomenon. And so this is something that certainly the international bodies that deal with labor regulation have turned their minds to, and that includes the ILO, which says that the emergence of gig or platform economy is one of the most important transformations in the world of work. It has published, next slide, please. It's published a digital employment diagnostic guideline and is going to have its first discussions for standard setting to ultimately come up with an ILO standard in relation to work for the platform economy in 2025. And those of you that are familiar with the ILO or have looked into this area, it often takes a long time to get things finalized and then percolate down to the country level. But when we do eventually see an ILO standard, I think you find that it can have a meaningful impact on legislation, and certainly as a guideline for courts and adjudicative bodies when they're looking into this area. And with that, I'll turn it over to Jake to talk about some of the more interesting cases in the gig economy realm.
Thanks so much, Matt. And yeah, so today we just want to highlight really two seminal cases. And when I say, just two cases, there's a trilogy of cases as it goes from the lower courts to the Court of Appeal all the way to the Supreme Court. So there's a lot of history here, and I can't in the next 20 minutes give you the full deep dive. But I think we can do a pretty good job just highlighting some of the key factors in these decisions and going through what this looks like in 2020. And I'll just kind of tell the crowd these are very new decisions and they're still ongoing. So we're going to look at Heller and Uber Technologies, which I'm sure you've heard in the news. It started in 2018. This case centers, and the kind of trilogy of cases we'll talk about just really centers on the permissibility of an arbitration clause in their services agreement between Uber drivers and Uber, the company. Specifically, David Heller, who is the named plaintiff, was required to sign a standard form services agreement in order to become an Uber driver in Toronto. Now, in the agreement, there's a provision that requires all disputes to be first submitted to arbitration in the Netherlands, in accordance with the International Chamber of Commerce rules. Now, just for your own information, the upfront cost to have an arbitration process in the Netherlands is $14,500, and that's not Canadian dollars, that is US dollars. So, let's do the math on that. And so, the court here found that it was quite exorbitant when compared to Heller's annual gross earnings of approximately $20,000 to $31,000 Canadian. And so this whole case really centers on, is this arbitration clause an effective financial barrier for drivers wanting to file a claim against Uber and really assert their rights? And so in 2018, David Heller brought a class action on behalf of himself and other Uber drivers and sought, among other remedies, a declaration that Uber drivers were employees within the meaning of Ontario's Employment Standards Act. And I just want to pause there because I think that's a really important point. Trying to widen the definition of an already broad definition under the Employment Standards Act would have a huge rippling effect, not only for Uber, but many other gig economy platforms and the digital space, as they would have certain legal obligations if the act were to apply to these drivers or delivery service folks. You would think vacation pay, termination entitlements. It would really reshape the gig economy. Heller also challenged the validity of the clause itself. And so in response, because the arbitration clause is under the International Commercial Arbitration Act 2017, which is a piece of legislation that governs the clause, Uber went forward with the proceeding and tried to move for a stay. Now, at issue, there really was no issue with whether or not Mr. Heller entered into the clause or was under duress. That really wasn't an issue. The judge opined in this case really was two things. Now, does the clause really mean an employment relationship or does it mean a commercial agreement? And does that then kick it from the reach of the act? And the judge found actually not. It didn't really matter if it was an employment relationship or a commercial agreement. He found that there are many examples where there are employment relationships that could go to arbitration. Think of collective bargaining between a union and an employer. And he also just found that he didn't want to opine on the reaches of the act because it just really wasn't permissible and not necessary in his assessment of the case. And then the second issue here, when looking at whether or not it was an employment contract, again, it was just whether or not there was jurisdiction for the court to actually look into this case. And he found that there wasn't. That really, if the arbitrator at the mandatory arbitration wanted to find that they were without jurisdiction based on the agreement of itself because they couldn't opine on employment agreements or had no jurisdiction on employment agreements, then that was up to the arbitrator to say they didn't have jurisdiction to then kick it back to the courts. So, in a nutshell, the big issue was Mr. Heller had to first go to the arbitrator to find whether or not the arbitrator was with jurisdiction in the Netherlands before turning the issue of employment status to the courts. And so the stay was eventually granted. And so if we move to the Court of Appeal on the next slide, they had a different view. So the Court of Appeal of Ontario reversed the judge's decision, holding that the contract required arbitration was unconscionable. The Court of Appeal's decision was really one of the first in Canada to find that an arbitration clause was unconscionable. They looked to another position in the Supreme Court of Canada case, Settle and TELUS Communications Inc. But here the Court of Appeal considered that the arbitration clause in context of the legislation following the approach in Settle was unconscionable, and they undertook the unconscionability analysis. First, they looked at the arbitration clause amounted to an illegal contracting out of the Employment Standards Act, and this was an application of the core principles from the Seidel case. And then second, the court held that the arbitration clause was unconscionable because of the significant barrier for someone to actually go to the Netherlands and to fight their case. And so they didn't even look at really the cost of travel to the Netherlands or the accommodation, but really it was just the barrier to entry of the arbitration itself. And going back to those numbers, that the arbitration process alone was $14,500 US in order to even start an arbitration. And they found that that was unconscionable in relation to the act, and relied on certain provisions under the act, which said that there was really just no stay application that could be moved forward. And so Uber appeals the decision and it goes to the Supreme Court of Canada. And if we could just go to the next slide. And in an 8-1 decision, the Supreme Court of Canada held that the arbitration clause in Heller's contract was also unconscionable, upholding the Court of Appeals decision. And they found it was in void because it attempted to contract out of the ESA. And so this allowed Heller's class action to continue and proceed to try to be certified. And then the stay was not granted. And so although in limited circumstances, a court can decline to stay proceedings in favor of arbitration agreement, one of the exceptions is for an invalid arbitration agreement. And the majority relied on the two-part test, similar to the Court of Appeal, to determine that the arbitration agreement was invalid. Now, when looking at the test, it requires proof of inequality in the positions of the parties and proof of an unfair bargain. And here the majority held that it is no longer necessary to demonstrate that the stronger party, so I guess in this case Uber, had the knowledge, constructive or objective, of the weaker party's vulnerable position. And I just want to highlight how big of a deviation that is that this hurdle has been removed so that if there's an apparent inequality in bargaining power, that party does not have to prove that anymore, that the court can take judicial notice of that. And so based on the fact that Heller was unable to negotiate the terms of the contract and was a less sophisticated party than Uber with fewer resources and in the inability to kind of broker a better deal, then the clause was found to be unconscionable, and then the stay was also, not upheld. Justice Brown also wrote a concurring judgment, but he came to the same conclusion, but did so without engaging the doctrine of unconscionability. He found that the arbitration clause was invalid because it violated the public policy imperative to provide meaningful access to justice. And so for Justice Brown, it was more so the fact that, Mr. Heller couldn't go to the Netherlands. That would be absolutely impossible, and that there's other remedies and other available mechanisms for him to access that justice here in Canada. And so the court in Uber, didn't really settle the question as to whether Heller or other members of the proposed class were in fact employees, but rather it just established that an arbitration clause in the contract was unenforceable in Ontario as it tried to contract out of the ESA, and that he could pursue his complaint in the Ontario courts. And so if we move now to Pokernick and Skip the Dishes, and sorry here, this is a decision coming out of Manitoba. And so Charlene Pokernick worked as an occasional food delivery courier for Skip the Dishes, and initially entered into a courier agreement with Skip in 2014. And this agreement provided that any disputes under the agreement would fall under the jurisdiction of the Manitoba courts. Now, on July 19th, 2018, so some 4 years later, Skip notified Ms. Pokernick via email that they were implementing a new agreement, and that would take effect in July 2018. Now, it's important to note that this revised courier agreement provided that any dispute between the parties under the agreement must be resolved through arbitration. Skip would pay the reasonable arbitration costs, and disputes would be resolved on an individual, not class basis. So again, I think Skip here turning its mind to both the arbitration and whether or not these workers could be certified as a class. And if we could just go to the next slide. An interesting note here is that on July 4th, 2018, Pokernick was contacted by counsel about becoming a representative plaintiff in the class action against Skip the Dishes. And so she agreed to do so. Also in July, when she received that email, there was a form in which, she could click through and accept the agreement. And it was, your standard form. And so one day before the agreement was to take effect, Pokernick filed an action against Skip the Dishes, alleging violations of the employment standards legislation, seeking a declaration that she was an employee of Skip and not an independent contractor, and claimed damages. She also applied for an order that the claim should proceed as a class action and filed a motion for certification. So again, within 1 day of it becoming a valid agreement, this class action was filed. And so moving to the court's decision here, the parties moved to the Court of King's Bench in Manitoba. And there they held that the original courier agreement governed the relationship between the parties. And so they were reviewing the agreement of 2014 and not the 2018 agreement. And there Justice Chartier concluded that the plaintiff had not agreed to the new terms. The plaintiff had informed Skip the Dishes she did not agree to the agreement, and did so not only under protest to continue to work, but also advised that she didn't click agree. And so the kind of mental gymnastics here with the justice was that because Skip never responded or objected to her email, the court considered that the defendant had acquiesced to the plaintiff's position. So even though she continued to work under the new agreement, by her saying she didn't agree to it and that did not clicking agree, was enough for him to find that the 2014 agreement, which did not have the mandatory arbitration clause, should rule the day. And so looking at the, we just could go back, sorry. Looking at the framework in Uber, they held that the arbitration agreement was invalid on the grounds of unconscionability due to the absence of consideration. And he was satisfied, the justice in this case, that there was a clear inequality in bargaining power, and then under these circumstances, the arbitration agreement was an unfair bargain. And so the court concluded that a part of the specific purpose such of an arbitration clause was to prevent class action proceedings, and the defendant would obtain an unfair advantage if the arbitration clause was enforced to terminate the plaintiff's proposed class action. And so this was not permitted. Skip the Dishes appealed the decision, and the appellate court held that the motions judged to refuse the stay was upheld and the appeal was quashed. However, the Court of Appeal did find that there was an error in looking at the 2014 agreement over the 2018 agreement because the new agreement was invalid by nature of either unconscionability or lack of consideration. The court affirmed that the motion judge's findings of the two elements of unconscionability, the unequal bargaining power and the resulting unfair bargain, were present in this case, and therefore that agreement was invalid. The court found that the nature of the contract and the presence of the class action waiver were two of the main factors that made the arbitration clause unconscionable. And I think it's important to just note a quote from Justice Steele here, that he states, "There's a tension between the overarching policy of the Act to encourage arbitration and the unconscionability doctrine developed in cases like Uber by the Supreme Court of Canada, which seeks to protect the more vulnerable contracting parties and collective recourse through vehicles such as class actions. And I think we're going to continue to see this play out in the courts of trying to balance, enforceable arbitration in commercial agreements, and that of those who are vulnerable workers and people that don't have that bargaining power. And it seems to be playing out in the courts, pretty specifically here. And so, because the motion judge went further for reasons in his decisions and denied it on the basis of unconscionability, that's the only way that the Court of Appeal in this case could uphold the decision. And so finally, just some takeaways from the recent court decisions that we're really seeing here today is that in Canada's like Uber and Skip the Dishes have large workforces, and yes, it's precarious work, but they are independent contractors rather than employees, and the jury really still is out whether employee protections will apply to these folks. The class actions, I believe, are certified in Uber, but it really hasn't played out in the courts yet. And I'd also like to just highlight, like I did in the other decision, that there's a major tension between promoting the arbitration and ensuring a fair dispute resolution mechanism, but also acknowledging that these workers have an unfair advantage. They are not separated or unionized, and I know Matt will allude to that very shortly. And so access to justice can also be precarious. In contrast, the US, the Ninth Circuit Court of Appeals, and the Supreme Court's decision in Epic Systems Corp in Lewis, they've reinforced kind of really the opposite, that arbitration agreements are enforceable and they can preclude class actions. And so Uber drivers are required to have their own individual arbitration rather than collective litigation. Again, really putting a stop to the open door that's in Canada. And so with that, I think it's a perfect dovetail to move to unionization and to chat about the trends that we see popping up.
Perfect. Thanks very much, Jake. And got to say, we're going to get into the weeds a little bit, but I think this is my favorite part of the presentation because some of the sort of head-scratching developments in this area, particularly for us as employer-side counsel. Just very quickly, and just so that we save some time at the end of the presentation to answer some questions, because we've got some really good ones that have come in. The poll we were going to do is to simply ask if has a portion of the gig economy been unionized in Canada? The answer, of course, or I wouldn't be doing a part of this presentation on it, is that the answer is true. In terms of unions and their sort of focus on the gig economy, I mean, it's been going on for certainly more than the last half decade, if not longer. And the sort of, I guess, the earliest significant development, if we turn over the next slide, is something called the Gig Workers' Bill of Rights, which was sort of prepared in conjunction between a number of sort of loosely affiliated and then more formally affiliated unions representing gig workers. The big one and the early one to this was the Gig Workers United, which is now affiliated with the Canadian Union of Postal Workers. Uber Drivers United, which has an affiliation now with the UFCW, and of course the Ontario Federation of Labor chiming in there as well. Essentially, this is it's a self-styled sort of Bill of Rights, which these unions have sort of advertised via social media, saying, "Look, if you're a platform employer, you need to sign on to this to ensure that you're treating your workers properly." And some of the highlights are full employment rights, and this is important to remember because of what I'm going to get to next. But again, a worker is a worker. They should have full employment rights, no carve-outs for things like minimum wage, sick pay, vacation pay, or other minimum employment standards. pay for all hours worked, access to benefits, residency, and the right to unionize. Next slide, please. And that's what makes really what we saw in January of 2022 so fascinating, in that one of the unions signing on to the gig workers' Bill of Rights was none other than the UFCW, who, the beginning of 2022, made a big announcement in conjunction with Uber that they had signed a, quotes, landmark agreement for some 100,000 drivers and delivery persons for Uber across Canada. Not that these workers were all unionized or that they were all going to be treated as employees and subject to all of the employment standards legislation of the various provinces in which they were located, but simply rather that Uber was working with the UFCW to ensure that its workers could have access to UFCW representation. Specifically, Uber recognizes the right of the UFCW to represent its drivers and couriers in an Uber dispute resolution process that involves account-related disputes, such as improper pay and wrongful deactivation. Interestingly, the cost of the representation, the cost of the UFCW representation is borne by Uber, and it's free to any worker who opts to have UFCW represent them. Now, your question is, well, what does Uber get in exchange for this? Well, and this is another surprising twist, Uber and the UFCW have agreed together to lobby governments to enact reforms that provide new benefits and worker choice on when, where, and if to work. And this appears to all dovetail into something that Uber has been lobbying the various governments on, is their flexible plus model, which ensures that drivers are covered by some employment standards and labor legislation, but not all. So your question is, what is going on? What is this? That's a question I asked, and fortunately there's a couple of great legal scholars, and I'll give a hat tip to David Dury, who's a labor law professor at York University, who's looked into this in great detail. And obviously a lot of thought did go into it, because on its face, there is technically no legal issue that would prevent a union from teaming up with an employer to promote the employer's legislative agenda. Similarly, a representation agreement between a union and an employer are not per se unlawful. Now, things are not, though, all hunky-dory, depending on how this plays out. And again, it's all been sunshine and rainbows for the last 2 years or so. But that's not to say that this won't change, because perhaps not surprisingly, this very large union in Canada partnering together with an employer that the labor movement had previously criticized as gutting and undermining its workers' access to minimum rights, has not been received that favorably. by organized labor. Not everyone working for Uber is on board. There are certain subgroups, one of whom called the agreement, quotes, the illusion of a union. It's the illusion of workers' representation, but it's not. It gives Uber the protection, the veneer of being progressive, while they continue to push for a regressive rollback of workers' rights. That's pretty harsh. Jim Stanford, who is the former longtime chief economist for Unifor, again, sort of is looking at this as sort of a quid pro quo kind of a situation that the UFCW gets quick access to rights and representation in an exchange. Uber doesn't find itself formally unionized, and with all the rights, obligations that come with it. Now, where do things go with this kind of an agreement? As I indicated, okay, it's the first of its kind. Is it also the last? Who knows? In part because if other unions, such as the Gig Workers United, decide that, for example, they actually want to formally try and organize a group of, let's say, Uber drivers. Well, Uber is told its drivers that the UFCW is going to represent them. Isn't that potentially interference with the administration and selection of a union and in violation of Section 70 of the Labor Relations Act? What about if another union says that, contacts Uber or any other digital platform provider, it's just an example, and says, hey, we want a similar agreement. But that company says, well, no, we've already got an agreement with our preferred union. What impact does that have under labor relations legislation? Again, it's still early days. This is something that obviously is going to have to be worked out. But at the end of the day, it's something to keep in mind because it's an area, certainly for unions that, particularly ones that may not have been in this area, to grow their membership, and it certainly won't be ignored. Where do we go from here? Look, there are legislative changes on the horizon in terms of both what you heard from Awale and from Jake. The stats don't lie. There are a lot of employees a lot of individuals in Canada performing this work, that those statistics are growing. And so there is, even if you're an employer side representative, I think it's difficult to argue that there aren't legislative gaps that need to be addressed. And there is certainly, given the population and the lobbying support, there is certainly momentum behind them. As I'd indicated earlier, I think that we would be wise as certainly as employer side council and representatives, to look to what's happened in BC and think that that's probably where things are going, both in the federal sphere and in other provinces. At the end of the day, though, look, the gig economy is here to stay, and it's going to continue to grow. And that means that it will be subject to legislation, to litigation, and to all kinds of dispute. And that means it's going to keep likely all of us on this call and you in the audience quite busy. So with that, we've got just a couple of minutes for some questions. There's been a lot of great ones. We'll probably only have time for a couple. Maybe what I will do is just, let's see, take a look here. But just a quick one that I'll handle first is, does the Ontario legislation have the effect of making independent contractors subject to minimum wage legislation? Well, my answer is going to be cheeky, but it's true. Well, if you're a true independent contractor, you're not going to be subject to minimum wage legislation. Are you an independent contractor or not? That's another 3-hour webinar. Maybe next, can an employee take on both gig type work as a contractor and also be an employee of the same company or employer? Awale, what do you think about that?
I'm gonna echo kind of your answer, because like all things, it depends, and it would largely depend on whether or not the gig work, the gig work, and I use quotations, that the employee is assigned really is gig work. So what level of control does the employer exercise on the worker for the gig work? If it's simply an extension of the work job duties that he's already performing as an employee, you can't then characterize it in a new agreement as gig work and try to evade your responsibilities under the Employment Standards Act.
No, I think that's exactly right. Another question is about the legitimacy of retaining services of consultants, sometimes exclusive to the enterprise or exclusive to the enterprise, and the notion of whether they are employed or not. Well, I'll go a bit further than to say that it depends in this case. I think that although that, the test for whether someone is an employee or an independent contractor is now a 40, almost 50-year-old test that courts have repeatedly applied. The concern I have as part of this question is exclusive to the enterprise. I would be concerned that if you're attempting to retain someone as a consultant, but they are exclusive to you, that begins to look more so like an employee. And certainly, if they're wholly dependent on you for their income, at the very least, a dependent contractor. I think we got time for one more question. Okay, when is a gig worker considered an employee, i.e. long-term gigs that go beyond a year, and can we remove severance obligations if specifically stated in an employment agreement? Jake, do you want to take that multiple-part question?
Sure. I think I'll start at the beginning. So the question is asking when, and I think that really does depend on what the person is doing. Right from the jump, you could be classified as an independent contractor, but to what Matt and Awale have said, are you really a wolf in sheep's clothing and really just an employee, but have the name of an independent contractor? And so it really just is dependent upon the work and not about how long you're doing the work or when you're doing the work. And at 6 months, then you've elapsed out of the gig economy and you've elapsed out of the independent contractor, and now you become an employee. But really, it's about what you're doing, and to Matt's point about the test of what an employee is, and are they being paid for services? It's a very broad definition, and are those services then being invoiced? Are they paid through a payroll? Is it taxable? How is that interaction within your business really working? And I think that would answer that question. And then to finish off with severance obligations, well, if they are an employee, then yes. But if they aren't, then no, you wouldn't have severance obligations. It's a commercial agreement between a service provider and your business. And so, that's where it starts to get a bit murky. And I think going to the case law with Heller and Skip the Dishes, is really, those industries really trying to rely on that arbitration clause and really to try to keep it within the commercial sphere so that we're not bleeding into employment contracts. And you'll see in the States that they've really just done a big dovetail away from it to say, nope, separate, you're a service, it's a one-time thing, ride, food services, that's a one-to-one contract service delivery. And so that's not employment at all. Whereas Canada's opened the door a bit more and said, whoa, like, it's starting to smell like that if you're continually doing, ride share or delivering food. And so I think the jury is still, quote unquote, still out there.
Great. Yeah. Wow. And sorry, this has been a power-packed 90 minutes. We've gone through a lot. Sorry we couldn't get to all of your questions, although, again, this is an evolving area, and that certainly keeps it interesting. I just want to thank everyone for attending today. That's all the time we have. And thank Jake and Awale as well for your terrific insights. Again, just a reminder, both for those of you who would like to take our survey, we really appreciate it if you would. Those of you who are looking for CPD credit, 2 QR codes there to click on. For BC viewers, the Law Society of BC title has been added to the chat as well. And then before we close today, I just want to remind you of our next session. It's the first of our 4-part weekly EDI series, beginning on October the 3rd on EDI, the basics. If you'd like to register for the event, check out the Fasken Institute section on our fasken.com website, and that will give you an overview of all our upcoming events as well. And with that, I want to thank you again for attending and wish you a great rest of the afternoon.